Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about testimonial accommodations and hearsay. Cases that should have gone to the Supreme Court of Canada, but didn't. In an aggravated sexual assault trial, a complainant attempted to testify in court. Unfortunately, due to fear of the accused, the complainant was unable to continue testifying. An accommodation was made for the complainant to testify by closed-circuit television, essentially from a different room or a different location over a television connection. Even still, the complainant was too afraid of the accused to continue her testimony. As a result, an application was made by the Crown to adduce her statement made to the police as evidence for the truth of its contents as an exception to the hearsay rule. The Crown argued that it was both reliable and necessary evidence in order to prove the case. The accused argued against it unsuccessfully, was convicted and lost, and appealed his conviction and attempted to seek leave ultimately to the Supreme Court of Canada, which was denied. And this case raises very important issues. While the hearsay rule that developed surrounding out-of-court statements that could be admitted in circumstances where the witness was no longer able to testify developed at a point in time where most of the instances in which this was being brought up were situations where somebody had been severely injured, had suffered some sort of a memory loss, or had died, we're now seeing these accommodations that were crafted into exceptions to the hearsay rule used in circumstances where essentially witnesses are less willing to cooperate. And while it is true that we have to approach people who are survivors of sexual assault with caution and with accommodation for the trauma that they've suffered, when it's in a court trial process, we also have to remember that there is a right to make full answer and defense, which includes cross-examination of the person who is making the allegations. Where the person is available to testify but unwilling to do so due to fear from somebody who they claim to have sexually assaulted but who is presumed innocent in law and in those proceedings, it's questionable whether this rule should be applied in the way that it is developed to admit out-of-court statements for the truth of their contents without allowing an accused an opportunity to cross-examine. And the Supreme Court of Canada really had the opportunity here to look at the ways in which the new technologies that we have that allow complainants to testify behind screens or with support people or with support animals or from closed-circuit television or from the comfort of their home while they are appearing on MS Teams, all can be used to provide appropriate comfort and safety to complainants without compromising the right to make full answer and defense. This is a different situation than a witness who is unavailable because they are missing or incapable of testifying as a result of something that has happened unrelated to the proceedings. And it's unfortunate that people are losing their right to make full answer and defense when other technological avenues exist. If this is the way that the hearsay exception is going to be expanded, the Supreme Court of Canada should chime in to comment on the way in which these expansions can be gatekept to keep them from being used in circumstances where it is just an unwillingness or an uncomfortableness about testifying as opposed to an inability to actually testify. And hopefully the Supreme Court of Canada has another opportunity to hear a case like this before the exceptions to the hearsay rule become the rule themselves. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. I'm Kyla Lee at Acumen Law Corporation. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.